My name is Jim Dearie. I've been an attorney for 25 years, practicing primarily in the areas of criminal defense, DUI defense, juvenile law, and civil litigation in the state of Ohio. Today, I want to address those of you who have been charged with DUI, which is now known as OVI, operating a vehicle under the influence of alcohol or drugs. When this short video is over, you will have a good idea about why you have been charged with OVI or the legal reasoning underlying your charge. In a subsequent video, I'll tell you what you should do next to protect yourself from jail, a driver's license suspension, and other potential negative consequences of an OVI conviction. There are two theories for OVI in Ohio. You may have been charged under one or both of these theories. The first theory is the one that you have heard the most about: driving while your blood alcohol content is over the legal limit of 0.08. Whether or not you were actually impaired by the alcohol in your system, you are guilty of OVI if a prosecutor can show a valid breath, blood, or urine test indicating that your blood alcohol level was above 0.08. Similarly, you may have been charged with OVI because you tested over the legal limit for marijuana, cocaine, or some other drug. If you are charged with OVI for exceeding the legal limit for a particular substance, then my defense of your case will typically focus on attacking the test result as inaccurate or in violation of the applicable rules for administering the test. The second theory for OVI in Ohio is that regardless of whether you were over some legal limit for alcohol or another substance, you were driving while impaired by that substance. How can the prosecutor show that you were impaired without a breath, blood, or urine test? By using the testimony of the arresting officer. The officer will say things like this: you were driving erratically, you smelled of alcohol, you had glassy bloodshot eyes, or you performed poorly on field sobriety tests administered by the officer. If you are charged under this theory for OVI, then my defense will usually consist of attacking the officer's qualifications, observations, or credibility. Also, we can usually offer other innocent explanations for the observations of the police officer. For example, perhaps you drove outside your lane to avoid an animal or some other object in the roadway. Or perhaps your eyes were bloodshot because you had allergies. Remember, the prosecutor does not get the last word on your case. You have the right to testify, and you have the right to present other evidence to defend yourself against the OVI charge. I will work with you to make sure we put on the best possible defense, one that attacks the evidence offered by the state and offers the jury numerous reasons to find you not guilty. So that covers the basic substance of OVI law in Ohio. If you want to ask me any questions about your specific case, feel free to call me, Jim Dearie, at 513-932-5529. As long as I'm not in court or in a client meeting, I answer the phone 24/7. If for some reason you don't get an answer, leave me a voicemail and I'll call you right back. Drive safe and take care.